taking over for a few minutes for Chair Lalonde, who's unavailable right now, and we're going to be doing an overview of bail and pretrial conditions with Ben Novogroski.
Thank you, Vice Chair Burdett. We still have a quorum.
Yeah.
We started.
We started with this, just making sure. All right, so I will share my screen. Now I can. Okay.
I think everybody's got a handout on that.
Oh, yeah, so this is all, there's a paper copy for you all to follow along with. So for the record, Ben Novogroski from the Office of Legislative Counsel, I will be going through a presentation on pretrial release, which includes bail and conditions of release. For those of you who are not new, this will be a very familiar presentation to that from last year. However, democracy in action, there have been new additions to this presentation based off of the legislation S-195 that was passed last year. That was vetted through this committee. So a little exciting that there was an update based off of something passed last year. So don't all get so excited at once. Especially you, Representative Grossman.
What was 195?
That was
Real quick, I mean, not even
so
just.
that's what implemented the change to bail laws, the pretrial supervision program, home detention, removing the $200 cap on misdemeanors if you've been charged with another one while you're on conditions, and other fine policy proposals.
So you're not just saying that just to keep me in the room?
No.
Okay, just checking.
So anyway, continuing on. Everything is already off the rails and it's been like 3 minutes into this presentation. So there are some important terms and definitions for everyone to know as we talk about bail and conditions of release. So what is bail? So bail is any security, including cash, pledged to the court to ensure that a person charged with a criminal offense will appear at future court proceedings. So in Vermont, it's defined as a security or cash. But bail as a concept is typically used to encompass conditions of release and other court-imposed factors outside of just the security itself. You can keep this as a reference tool as well, so you don't have to take notes.
It just helps me with my processing.
That's fair.
And for the sake of time, I know there's a lot here for half an hour, it looks like. And if we could, I know it's out of the norm, but maybe main thing I think right now is for Ben to get through this.
It's speed. Yeah, okay. Well, I'll get out of my own way.
No, where I'm going is save your questions.
Okay, fair enough. So then there's an appearance bond. So these are essentially forms of security. So this is a written agreement to pay a specified amount if someone fails to appear. There's a secured appearance bond, which is that written agreement and a portion, usually about 10%, that is paid to the court prior to release. Then there's a surety, which is where a person agrees to be responsible. So a third party for guaranteeing the court appearance of another charged with a criminal offense, or someone who agrees to be responsible for guaranteeing that the person complies with the conditions of a peace bond. We are not talking about peace bonds there. Even though they're mentioned in the bail statutes, they are a separate court process. Then there's a surety bond, which is that written agreement where someone would guarantee that appearance of another and pledges to pay the amount to secure the appearance if someone fails to appear. And then there's flight from prosecution. Flight from prosecution is essentially what bail is aimed to mitigate. It's any action or behavior undertaken by a person charged with a criminal offense to avoid criminal or court proceedings. So those are the general operating terms. unless there are, well, we're saving questions to the end. So moving on to pretrial release in general. The overarching concept to remember is that people are innocent until proven guilty. So you need a really good reason to hold someone pre-trial prior to a guilty verdict. This concept is grounded in both the US and Vermont constitutions and detailed in 13 VSA chapter 229, which I will go into a little bit later into the presentation. The sole constitutionally legitimate purpose of bail is to ensure that someone appears in court. That is the number one constitutionally legitimate purpose. It can't be used to punish the defendant or to protect the public. That is not what the purpose of bail is. But conditions of release can be used as a mechanism of public protection if conditions related to bail are insufficient to protect the public. And we'll get into the analysis of how that unfolds later on. So the constitutional requirements. So this is enshrined in Chapter 2, Section 40 of the Vermont Constitution. It provides broader rights than the US Constitution. So bail is the presumptive goal. So under the Vermont Constitution, all persons shall be bailable by sufficient sureties, except in 3 circumstances. 1, when someone's been accused of a crime with a possible life sentence or death sentence. It's only life now because there's no death sentence in Vermont. Someone who has been accused of a violent felony, and there are certain procedural and evidentiary safeguards that you have to get through in order to hold someone. We'll get into that later. And then if someone's waiting sentence or sentence pending appeal, but we're not really talking about that situation pre-trial. Someone held without bail shall be entitled to an expedited review by a panel of 3 Supreme Court justices if they're unsatisfied with the determination of the lower court. Essentially, anybody held for a violent felony, that kicks in the speedy trial requirement of the Constitution. So you have to schedule a trial with not more than 60 days after bail is denied. If it's not started within that time period, the court shall immediately schedule a bail hearing and set bail for that person. Again, to make sure that we're keeping in mind since they haven't been adjudicated guilty prior to their trial. So those are the constitutional foundations. So what are the statutory foundations? So 13 VSA 7554 is what is commonly referred to by prosecutors as the Bible for bail. So this is like the go-to statute. So at the outset, any person charged with an offense, other than those 2 exceptions that we just talked about, must be ordered released at their initial appearance before a judge. But it's according to the requirements of this section, one of which is that they must be ordered release unless the judicial officer determines that such a release will not reasonably mitigate the risk of flight from prosecution. So again, you're hearing bail, risk of flight. That's the nexus, or the primary nexus that we're talking about here. So what's the scope and limitations of bail? Bail, again, only used to assure the person's appearance in court, not as a means of punishment, nor to protect the public. The statutes create a presumption in favor of pretrial release, with the courts required to impose the least restrictive conditions unless the defendant is determined a flight risk of flight. Bail, secured appearance bonds, or appearance bonds cannot be imposed at the initial appearance for misdemeanors if the person is cited for the offense, or at the initial appearance or temporary release from eligible misdemeanor eligible for expungement, unless the court determines that imposing bail is necessary to mitigate that risk of flight. So once the court engages in that analysis, if they think it is appropriate to issue bail, that initial bail amount is capped at $200. But because of S-195 last year, that $200 cap does not apply if they're out on conditions and then they are brought in for another crime. Then that $200 cap wouldn't apply in that situation if it was for another eligible misdemeanor. I would ask for questions because I know they exist based on the faces that I'm looking at. But do you want me to wait?
If you think we're on schedule, I guess.
I'm going to continue on.
Okay, for Angela and Ian, we're gonna try to hold our questions unless Ben asks, just to make sure he can get through the whole presentation.
And then again, those constitutional exceptions that I talked about, they're governed by 7553 of Title 13 and 7553A. So those are the statutory implementation of those constitutional requirements. So let's talk about persons held without bail under those two statutes. There are those three constitutional exceptions that apply: life imprisonment, violent felony, and then awaiting sentencing, but we're not talking about that one here. So 13 VSA 7553, that's when you can hold someone without bail if they've been charged with a crime with a potential sentence for life imprisonment. There has to be evidence. The guilt is great. This is a whole process that the court gets into. There's a presumption of detention under the statute. The rules of evidence do not apply. And so it's easier. So basically in these circumstances, the prosecution will have to show that evidence does exist, but they don't necessarily have to present it in the traditional way. But if they fail to meet that burden and the evidence of guilt is not great, the court maintains discretion to release that person under the bail Bible statute and the restrictions that it imposes. We'll get to that later. Violent felony, similar process. The crime has to be a felony, an element of which involves an act of violence against another. The evidence of guilt must be great, and then clear and convincing evidence shows that release poses a substantial threat of physical violence to any person, and no condition or combination of conditions will reasonably prevent that physical violence. This was clarified last year as well about the evidentiary standard needed for the for really part 4. And it now is aligned with 13 VSA 7553, where you show evidence exists, but you don't necessarily have to present it in the traditional way that you would in a trial. And that's sort of the concept here, is that it's this middle ground between the full evidentiary requirements that are necessary for a trial, but not having to conduct the trial at an earlier stage. And so this is sort of a middle ground where we're saying, well, we want to know that you're not just fudging it, but you don't have to go through the rigors of getting witnesses and bringing them in and introducing statements through those witnesses. You could just introduce them. So that was a clarification last year that the General Assembly made. And then again, there's that 60-day trial requirement if someone is held. If the defense doesn't request a waiver and it's not held within that time period, then a bail hearing will be set to release them, most likely with conditions. Bail and risk of flight. How is someone determined to be a risk? So courts consider these explicit factors in addition to any other factors that the court deems relevant. So you'll see the first two were in statute prior to last year. The bottom 3 are because of the work that the legislature did last year through S195. Now you will see there was testimony last year from the courts that many judges already used the new factors in their assessments of risk of flight, but it may not have been consistently applied, in Orleans County in the same way that it would have in Bennington County. So to ensure that they were all being analyzed in the same way, they were memorialized in statute. And so these new ones are whether someone was released pending trial for another offense, if they're already under DOC or federal supervision post-trial, and then compliance with court orders and appearances in a criminal prosecution. If the court determines that the person is a risk of flight, it again must craft those least restrictive conditions or combination and consider on the basis of information that's available to the court the nature and circumstances of the offense, the weight of the evidence, so how much evidence is there and how probative is it on the charge, to the charge, the person's employment, their financial means, including the ability to post bail, so that is a consideration. If someone, so within the Supreme Court and Vermont case law, so bail doesn't necessarily have to be affordable, but it cannot be excessive. I think that's a factual determination that the courts make. So it doesn't have to be so cheap that everybody's going to afford it, but it also can't be so high that there's no way anybody would, if that makes sense. The person's character and mental condition is a factor, the length that they've lived in the community, their essentially criminal record, record of appearance, flight from prosecution, failure to appear. So those are all things that the court factors in when determining bail. So if those conditions and considerations are insufficient to protect the public, then, I'm getting ahead of myself. So those are the factors to determine which conditions of release should be imposed related to bail. So to keep someone coming to court. So those conditions of release are, you can place someone in custody of a designated person or an organization that agrees to supervise the defendant, essentially a surety. So for instance, if there's doubt over someone's ability to abide by the conditions, they can get a family member or an acquaintance to agree through a written agreement to be responsible for it. And or it might be different now that we can, that the legislature's put in new conditions, but basically they're saying we'll report violations. If they commit a new crime, we're going to report them too. So there are a whole bunch of responsibilities that come with that designation. You can place restrictions on their travel or association. So, you can only go to and from work between the hours of 8 and 5 p.m. Something like that. Require participation in an alcohol or drug treatment program. Typically, if you're charged with DUI, and let's say it's your third DUI, chances are that's going to be a condition that's imposed by the court. And again, the court does consider the ability to comply with such an order and also whether those treatment services are available. The courts, I think, would do the best job that they can to make sure that someone can't meet a mandate that isn't available to them. Again, considering financial means, they can require an execution of that secured appearance bond or in cash or another security in a sum that's not exceeding 10% of the full amount. They get that money back if they comply with that bond or surety. Again, require the execution of a surety bond and make sure that there's enough solvency or cash to pay the bond, again, upon consideration of financial means, and then any other condition reasonably necessary to mitigate that risk of flight. There could be no contact conditions ordered, so don't contact the victim of the crime. Let's say in a domestic assault case between a husband and wife. The husband committed the act. One of the conditions would be no contact with your wife. How that would be done if they lived in the same house would be up to them, but it would be a requirement that they'd have to abide by. You can also, and these are two new ones as of last year, place a defendant in home detention or place them in the pretrial supervision program. And again, these new conditions came out of S-195 last year, and I'll get into the details of those later on. So public protection and conditions of release. So if all of those conditions are imposed through bail and the court determines that they're insufficient to protect the public, then you can get to conditions of release that are aimed towards public protection. So it's a secondary analysis in this whole equation. And again, has to be the least restrictive condition or combination of conditions to achieve public protection. And again, it's based on very similar set of factors that the court considers for the imposition of conditions related to bail, nature of circumstances of the offense, the weight of the evidence, have they been released prior to trial, which is new from last year, under DOC or federal supervision. Also new from last year, compliance with court orders and appearances, new from last year. Ones that were not, family ties to the community, employment, character and mental condition, length of residence in the community, the record of convictions, record of appearance, basically their criminal record as full. So those are the conditions related to public protection that can be imposed if the ones imposed related to bail are insufficient to protect the public. And these are, again, a similar list of conditions that can be imposed. The only real difference is there is one about tailored to a law enforcement officer. So you can suspend a law enforcement officer's duty if the officer is charged with embezzlement in their official capacity and it's necessary to protect the public. So that's the only difference between the bail conditions and the public safety conditions. Otherwise, they're all the same. So home detention. Let's talk about this program that already existed in one form, but was expanded last year to S-195. It's essentially, think of it as jail in your home. It's the most restrictive form of condition. It's the most restrictive condition that can be imposed next to incarceration. So it restricts a defendant to a pre-approved residence continuously unless they have exceptions for work, school, or medical. It's governed by 13 VSA 7554. The two different bases that exist are one for the inability to pay bail. This was the initial version of the program. And last year, the legislature passed a new basis based off the violation of conditions of release. And in both programs, a defendant gets credit for time served during home detention if they are ultimately sentenced for the crime that they're charged with. So the first program, the old one, I'm going to say, was the inability to pay bail. So this kicked into gear when a defendant who's detained in jail or in prison for more than 7 days for lack of bail. So basically bail was set and they weren't able to pay it. And so they were then detained. So an option that was useful to them is that they could make a request to the court to be placed in home detention rather than be incarcerated. This can be done by the defendant, by DOC, or the court. Because remember, at this time, they're under the supervision of the Department of Corrections because they're being held in a facility at this time. So that's why DOC can also have the ability to make this request. Prior to scheduling the review, DOC engages in an assessment of the proposed residence to see if electronic monitoring can work there, because it's all based on cell coverage. And as we know, cell coverage in Vermont is spotty, to say the least. So if you don't have cell service at your house, chances are that house is not going to be appropriate for home detention. But in determining whether home detention is appropriate, kind of separate and apart of the suitability of the residence, it's an editorial error on my part. The assessment is, look at the nature of the offense charge. If it's a domestic violence situation where the person asking for home detention is also going to be residing with the victim, probably not going to work. You look at their criminal history. Is this someone that has a pattern of it? Have they been on home detention before? Were they compliant with that home detention, with those home detention requirements? And then finally, risk or undue burden to other persons. So it's this three-pronged analysis that the court engages in when it comes to an inability to pay bail. And then DOC, since they're already under the supervision of DOC, may revoke that home detention status for any unauthorized absence or failure to comply with any condition of the program. Because really, you got to think about it, they would be in jail but for this program. So DOC has the ability to revoke that really without much process. Then there's the new program.
We've got about Well, I'm actually thinking we probably should find time to finish up the last couple slides because I don't want to, we have quite a bit to dig into this other issue, starting at 1:30, a couple minutes
Okay.
ago. But maybe just double check, is Jay Johnson online? Is she available? So hold that slide. We will find another 10 minutes to slip in those last couple slides, and questions. We'll find time.
Okay.
All right, sorry to.
Oh, I live to serve, Mark.
Yeah, I appreciate it. So,
We tried to get you done, but.
Yeah, I'm a little long-winded too, so that doesn't really help.
no. It's all important information. We're going to be dealing with it during the session. So, thank you, Ben.
Yeah.
Thank you very much, Ben. Thanks for being available. So Tucker, are you going to join us at the head of the table, or are we going to just start with Jay?
Jay's gonna go first.
Okay, all right. Just bear with us for a moment, Jay.
Yes, I just want to apologize to Ben, but thank you, Ben.
Oh, it's all good.
He's right around here. We can bring him back fairly easily. So thank you very much, Jay Johnson, for being available. And I'll turn it over to you if you can introduce yourself for the record and proceed. Thank you for being here.
Sure. Thank you, Chair Lalonde. I appreciate the invitation. And good morning, members of the Judiciary Committee. I am Jay Pershing Johnson, Governor Scott's legal counsel. I was invited to testify in your committee today on the governor's legislative proposals for public safety. Thank you so much again for having me, and I'm sorry I can't be with you. It's nice to see familiar faces, and I look forward to meeting all the new members and working, as always, with you all this session. So for those of you who don't know me, I advise the governor and senior staff on any number of issues, most legal issues, as they arise day to day. I review everything coming to the governor for approval, and I review extraditions for sending fugitives from justice back to the state they fled, and requesting fugitives from Vermont to be returned. And I review every bill the legislature passes, so I'm lucky in that regard. In the larger constitutional context, of course, the governor exercises the supreme executive power, and his most fundamental duty is the faithful execution of the laws. So you will often hear the governor say that public safety is one of his most important responsibilities. So I am also the governor's liaison with various stakeholders in the criminal justice system. I work closely with the Department of Public Safety and the Department of State's Attorneys and Sheriffs on community safety and violence prevention issues. I'm also a contact with the Defender General's Office, the Office of the Attorney General, and the Center for Crime Victim Services. Monica Hutt and I, Monica is the Chief Prevention Officer for the state in the governor's office. She is the liaison to the Agency of Human Services, and she and I work together very closely on the intersection of youth behaviors, substance use, and mental health with the justice system, and how we can work on solutions on that side of the house in that committee to improve service delivery to individuals who are involved in the justice system. So like every year, our package is intended to address the public safety issues we know our communities are facing. And I think, as we have heard, Vermonters want accountability. They're frustrated with what they view as a catch and release system, and they believe untreated drug and mental health issues to be behind much of the crime and disorder they experience in their communities. I think, unfortunately, our proposals were initially spun as an effort to increase penalties, which actually is not the case. We're not proposing new crimes or new penalties or increased penalties. We're looking for our institutions to use the tools they have to ensure swift, certain, and fair justice for defendants, victims, and communities. And I think we did some of that successfully together last year, and I'm hoping that we can do more of that successfully this year. So I do believe you're pretty familiar with our proposal to repeal raise the age for 19-year-old adult offenders and reform our youthful offender procedures to ensure accountability. I appreciate the conversations you've been having over the last 3 weeks. I think that's all been very important. As you know, in April of 2025, if the legislature takes no action, 19-year-old criminal offenders will be treated like children in the family court. And because they have reached the age of majority, and as you have heard, there is no way to hold these young adult offenders accountable for compliance with their family court conditions of release. Moreover, Vermont would be the only state in the nation to increase the age of juvenile jurisdiction to 19. So this is not evidence-based policymaking. Raising the age of juvenile jurisdiction to young adults is really an untested academic exercise. As you heard yesterday, Massachusetts raised the age to up to 18. And the best data to date is not recommending expansion of that program. Vermont here is the clear outlier. Raising the age up to 20, which is what we're proposing, is an unnecessary diversion of DCF resources from the younger age groups where these resources are most needed and making the most impact. On this point, in the governor's 2024 budget address, he was clear on his position where he acknowledges that he signed the Raise the Age bill. But he said, let's start with something you don't hear too often in this building. I may have been wrong. I've supported and signed some of the very legislation I'll ask you to change today. I agree people deserve second chances and maybe even third or fourth, especially when it comes to mistakes made as a young adult or when struggling with addiction. But I wish I had better anticipated the challenge of implementing laws to raise the age of criminal accountability. Because we weren't ready, we put the policy idea ahead of the fundamentals, the real work of actually helping our youth. Like many other areas, we moved too far and too fast into a policy experiment. And we didn't plan for or build the system needed to address extreme cases or have the workforce to support it. We focused so much on our well-intentioned goals that we didn't think through all the possible consequences, like what adding older, more violent youth to DCF caseloads would do, or how traffickers would exploit young adults to run their deadliest drugs and expand their markets. He says, I'll admit the same for bail reform, which I signed because I agreed with the goals. But again, there were negative consequences because we limited a valuable tool. And on top of that, conditions of release aren't effective, which makes it harder to prevent people from harming their neighbors and communities over and over and over. So all of that remains true today. I think consistent with what you have heard over the last few weeks. And I would note that the legislature's willingness to reconsider bail reform and not throw the baby out with the bathwater, but to reconsider reform has anecdotally resulted in some positive outcomes, as Chair Lalonde mentioned yesterday. So again, I think this is the approach we would like to take. I was happy to hear Representative Arsenault, and I'm happy to give her credit for this, coin the phrase accountability gap, because our proposal to repeal Raise the Age for 19-year-olds proposes to make changes to the existing youthful offender program to close the accountability gap for these youth. Remember, the youthful offender statutes prefer diversion where possible. And we know that prosecutors are diverting 20% of their caseload now. For youth receiving the benefits of a youthful offender designation, which offers all the benefits of Raise the Age, our approach would facilitate a more timely connection between offense and consequence by offering prosecutors the discretion to keep youthful offender cases in the criminal court as sealed proceedings or direct file in family court. So I think we believe that moving forward in a different direction sort of addresses the kind of thing you're struggling with, which is how do we offer youth the benefits of family court, but since they have reached the age of majority, how do we put some teeth and enforce the probationary terms that they're going to be subject to? How do we make sure that they comply with those And how do we make sure that we have a speedy process for returning them to accountability if that's necessary? So hopefully we can have more conversations about our options there. Second, we're going to continue to address the issue of repeat offenses. Tucker, who's speaking after me, can expand on this, but we will seek to revise current law on revoking bail to make it a tool courts and prosecutors will actually use to hold violators to account. We have a statute. It's not really being used very often. It's not very effective because we don't have clear bail revocation standards for defendants who reoffend while out on bail or repeatedly violate conditions of release. We're proposing to update our standards to meet the test for constitutionality articulated by Vermont's Supreme Court. We are also, again, proposing universal sealing of criminal records to replace our current practice of erasing them. I want to thank this committee for all of its hard work last year to get a sealing bill to Senate Judiciary. And it's my understanding Senate Judiciary will be starting with a sealing bill this year. I believe one has been introduced already. When a record is sealed, a person who is not reoffending still has the opportunity to pursue better jobs, higher education, obtain loans, or lease an apartment, but leaves those records available for criminal justice purposes and all legally required background checks. Third, we're going to be looking to limit the authority of the courts to suspend criminal sentences for repeat violent offenses. Many Vermonters would be surprised to learn that Vermont courts can and do suspend the sentences of violent criminal offenders. This means that an offender could be convicted, receive a sentence of 30 to 40 years for a violent crime, and be released into the community by a judge, despite repeat offenses and supervision violations. We propose limiting the ability of a judge to reduce or suspend a sentence of a person convicted of more than one violent crime. Fourth, we're looking at waivers of extradition. This is a little bit of a technical area, but I review extradition requests from other governors who seek to have a fugitive from justice returned to their state for court proceedings. I work with the Office of the Attorney General in reviewing these requests, and the Office of the Attorney General reports that about half of the extraditions requested of Vermont are for the return of people who have already voluntarily agreed to waive the right of extradition as a condition of release. So this means in exchange for their release, say in New Hampshire, they agree that if they flee prosecution and are arrested in another state, that they can be, and then the court orders an arrest warrant, they can be returned by law enforcement. So basically they're picked up and taken back. Right now, Vermont has no statutory process for respecting the waiver of extradition made in another state. In fact, when a fugitive from justice from another state has clearly already fled justice and is arrested in Vermont, our courts often release them pending the issuance of a governor's warrant. So our proposal would authorize law enforcement to return fugitives from justice if they have waived extradition as a condition of release in another state. Further, we need to redefine recidivism to more accurately reflect returns to incarceration and create additional measures for successes as well as for violent reoffenses in Vermont. I know that you had some discussions yesterday about apples to apples comparisons of recidivism definitions. Our Department of Corrections has recently done some work in this regard and found that this is an area where states are all over the map. So I think what we at the very least need in Vermont is a metric or metrics that work for us. At least 24 states have data that's been used for the purposes of US Department of Justice recidivism reporting, but none of these are New England states. The state's definition of recidivism is narrow, and we believe that there's an opportunity there to improve the metric. We're also open to working with your committee, with the state's attorneys and sheriffs, who I think have asked Ledge Council to draft a bill. So we're looking forward to more conversation with you about that definition. I'm looking forward to, I'm looking forward to further conversations about that. I think that it's important. I think that it will be useful. Say, for example, when we're talking about suspended sentences for repeat offenders, or reduced sentences for repeat violent offenders. If we have a metric that tells us if this person is a recidivist, a violent recidivist, that may be something courts can factor into sentencing decisions. Finally, and I think you discussed this a little bit, is the 2024 pretrial supervision program for repeat offenders, which was implemented in Orleans County at the end of last year. We're hoping to get some outcomes data, and we're considering our options for expansion. This, of course, requires money. I don't want to get out ahead of the governor on the budget, but this is a program that I think that we are happy to talk more about. Then the last plank of the governor's public safety package recognizes the need to protect communities from the harms of drug and alcohol addiction. I think I am hoping, and I think you maybe did a little bit of this last year, that there can be some joint sessions with the healthcare committee and the Health and Human Services committees. It's an important topic where I think that there's overlap. So first, we seek to repeal the July 1, 2025 prohibition on continued transport of disorderly and violent individuals who are impaired by drugs or alcohol to corrections facilities. So there's a provision in law right now that as of July 1, 2025 would prohibit the transport of these individuals to corrections facilities. Right now, we really don't have good alternatives. So this would leave law enforcement with really no options, or very few options. To go along with that, however, we're proposing to retool our or underutilized public inebriation program beds as public inebriate and crisis mental health beds. There was some funding of that for that last year that was left over, because generally that money is not being utilized for that purpose. The hope is to more effectively connect individuals placed in public inebriation beds with appropriate longer-term care and services. We think the two are needed to work together, because you're going to have violent people who are inebriated in the community who simply can't be accepted into a program that's run by caseworkers, essentially, and healthcare workers. You need to have the option of transporting individuals to DOC facilities. Second, we're coming up with a drug treatment strategy to more effectively reduce drug use and associated crime plaguing our communities. We think we need to reduce the number of people who are addicted to drugs in our state. I believe that meaningful action on crimes like retail theft requires effectively connecting addicted offenders to treatment and long-term recovery. We're working on building a system that can deliver a swift and sustained connection to addiction treatment and recovery by retooling and reinvigorating existing systems. Our goal is to provide individuals with a seamless transition from one level of care to another into successful recovery. Ideally, this includes connections to recovery housing and employment resources and other longer-term resources. These levels of care can be paired with conditions of release, pretrial supervision, the AG's drug treatment diversion program known as Tamarack, and even pre-charge diversion. Any avenue where an individual might have an incentive to choose treatment in that moment. This system can also include comprehensive treatment, which includes therapy within corrections systems, to create a new and effective pipeline for successful treatment and recovery for convicted offenders. That's actually it for my remarks. I don't know if you have any questions or if you want to move on to Tucker, but that's the package. The intent is for most of it to work together. And again, I look forward to working with the committee.
Sure. No, we will have some questions, but I just want a couple comments and as well before we get to that. So a lot. First of all, thank you very much for providing the bill draft. I really appreciate it. I mean, it happens that a number of the provisions that you're talking.
Bill draft. That was going to be my question.
Well, there's not a bill draft yet. My understanding is they've provided language to legislative council who hasn't.
Can we have that?
I would imagine so. If we, so before I get to that, questions, I'm getting questions already, which I will try my best to answer them too. So we've been, I have a number of actually separate bills on some of these issues. I have a bill that I've been working on and with the Crime Research Group, state's attorneys, attorney general, and I think others on recidivism definition. And we don't have that bill out yet. Bail revocation, I've been working with legislative council this past fall. There's the raise the age. I've had a bill request in, but we're trying to figure out what to do with that still. Just so part of the reason I'm saying that, and part of it, and further actually, is that you have this omnibus bill that's coming, and there are going to be parts that actually the Senate Judiciary is working on sealing. We're working on raise the age. I think probably the public inebriate may be in corrections. So it's not likely that this one bill is going to, make it all the way through as one bill. There are probably going to be separate bills. I just am flagging that for you, that there's a lot of these initiatives are already kind of going on. I will definitely thank you for the long-term recovery. I think that is awesome, that's part of this package, and really looking forward to seeing what goes on with that one. Also in other committees besides our committee. But just wanted to flag that for you, that we are working, off of what you provided, having that inform some of the bills that we already have that are being drafted. So the question that to me, and I'll now ask to you, is when are we able to see the language that has been submitted to legislative council? Is that something that, so we can start becoming familiar with it? I mean, I have seen the language, but is that kind of for public release, what you have, or where are you with that? Is that something we could put on our website so that folks can actually start seeing the language, even though everybody would have to understand that that is not the bill that's gone through our legislative council yet, obviously.
I mean, from my perspective, the day that we sent it to the legislature, it was public. So,
Okay.
I mean, that's typically how our communications are required to work by law. I do appreciate the concern, and I appreciate the sensitivity. But I think that, of course, if you wanted to take each piece and look at them and compare to what you're proposing, from our perspective, the omnibus bill gives us something we can measure our proposals against. How are we doing? What is being introduced? Is the legislature taking it up? Does it look anything like our proposal? Like that gives us a bottom line, so to speak. And then, but of course, we're happy to, we realize it's your process. We're happy to work with you, however these bills end up coming to the floor.
Okay, right, I appreciate that. So I'll open it up for other questions, and I will get this over to Nate so it can be put on the website. So other questions, or were all the questions where's the bill? All right, Barbara.
Hello. So I don't think I could take notes fast enough, so I'm just going to ask a couple of questions. So one thing that I'm wondering about is the public inebriate and crisis mental health beds. I'm just wondering, it's been a few years since I've worked at a mental health agency, but I'm wondering about how those two programs necessarily co-locate, and maybe you weren't thinking co-locate, and I'm just wondering how involved has the sort of the mental health providers or sort of best practices come into play with this part of the business.
Well, honestly, Representative, I think that those are better questions for the Agency of Human Services, how they're planning to structure that. But I think part of the concern is that we see a lot of co-occurring disorder. So I think that how, and I think that we need to be prepared to operate our public inebriate beds maybe in that light. But I think that obviously sometimes public inebriation is public inebriation. Sometimes it's a co-occurring disorder with a mental health issue, and that person hopefully will be put in one of those beds and given the opportunity for more treatment. So I think that that really is a better question operationally to ask the Department of Mental Health and or Substance Use Division. We're really looking to see those two departments work hand in hand on some of these issues. So I think how they structure that is a great question for them.
Right, because I'm thinking, I know staffing wise, like usually the public inebriate beds are medical personnel and a lot of medical monitoring going on, where crisis stabilization could look really different. So will there be money to appropriately fund that new initiative?
Well, as far as I'm concerned, it's not a new initiative. There is money from last year, as I said. So we don't expect that we're going to be asking for more money this year.
Okay.
We expect to use the money that was allocated last year, not used.
So thank you. I think I have two more questions. One is, so repealing the law that would go into effect July 1 to prohibit transfer of people to correctional facilities.
Yes.
So it sounded like some of the people that would not be going, and again, I was trying to listen really and take notes, are people that are struggling with, like, they might be the people that you'd be sending to the crisis mental health bed, right? Like, it's people who are having some challenges there because of drugs and or mental health. Yes or no? Was I missing who that is?
Right now, what we're hearing from law enforcement is if law enforcement ends up picking up a person who is inebriated, say visually impaired, that person may or may not have mental health issues, that law enforcement officer may or may not have any idea what the combination of events going on is, but that person is violent in the community and clearly impaired. They need to be able to take that person to a place where they can, I guess what you'd say, sleep it off. I don't know. But I would say that very often a designated agency is not going to accept a person who's violent, and you need a bed. So law enforcement is concerned that if you shut down DOC as an option, they have few or no options for placement of that person. So that's the simple purpose of the repeal.
So those people would not go to the next initiative, the public inebriate and crisis mental health beds. The idea is that they would go to some designated beds at DOC.
Which is what happens now.
So the public inebriate and mental health beds are not to take the place of that.
Well, the public inebriate and mental health beds are not for violent individuals. I mean, they may be able to take disorderly individuals, but there's just going to be, however they operate is going, but that's kind of the plan. It's not an either or, it's a complementary system. And DOC is not intended to be an incarcerative resource. It's just a secure bed for a person who's violent and impaired.
And my last question is just about repealing the 19-year-olds. I'm wondering if you're feeling like, I know you talked about, and I think I know I realize DCF is lacking resources to do what we would hope that they'd be able to do. Are you feeling like DOC is okay with their current resources and keeping 19-year-olds, or are you hoping to improve services for that population at DOC?
Well, I think once an individual is in the youthful offender program, as I think DCF explained, there's sort of a lead agency. And I think that, that's certainly something that we need to talk I mean, DCF and DOC are doing it now, right? Is there a need to improve those services? That's something you should, consider. We would hope that the youthful offender population is being served adequately. If we don't feel that it is, then, that's something to consider. But I don't think that the default is pushing them into family court with caseworkers who can't manage them.
No, and I'm excited to redefine recidivism because I think our recidivism definition has been unusual. I'm concerned about how high our recidivism rates are in our correctional facility and how much we pay. And so I'm just hoping, and I know you talked about having more mental health counseling. I'm hoping we can improve services and lower recidivism rates so that it feels like a good, besides keeping people locked up that need to be locked up for the safety of the public and for consequences, that rehabilitation can actually make a difference and we're not just sending people in and out.
I completely agree. I think that the best thing for public safety is to reduce the threats in the community that are being caused by sort of human services issues. If we can effectively treat people for substance use, if we can effectively provide crisis management and healthcare services for people with mental health issues, I mean, that's the best way to keep a community safe. And, when there are people with criminogenic behaviors that aren't indicating that there's any change and you can't there's no real treatment option, that's when you have a DOC facility. Like, ideally, that's how it works.
Right.
And that's where I think we have to be really talking about pairing human services in many cases with a forensic population. It's not always an easy conversation to have because in the healthcare committees, you're very focused on clinical need, which I appreciate and is appropriate, say, for a healthcare committee. But you also have to pair that with a conversation about public safety and how do you manage the needs of communities and the rights of victims and the disorder that communities are experiencing by using all the tools at your disposal.
And hopefully doing more and more prevention and.
Right.
Yeah.
That's ideal.
Great. Thank you.
And then Tom.
So hi, Jay.
Aaron.
Hello,
Am I
Representative.
going?
Yes, yeah.
Hi, Jay.
Ken Hunter.
Hi, Representative.
So I don't want to take up your time if Tucker's going to answer these questions, but I've got probably 5 of them that I was trying to keep track of. But just going back to the so-called catch and release situation that we're in, I assume if that was to stop, or we got a lot better handle on that, we wouldn't have near the court backlog that we have. Would you agree with that?
Well, I guess let me just reframe that a little, which would be what
Oh, feel free to.
We've heard prosecutors, and I assume that the defense bar would agree, we have, if not a handful, maybe more than a handful, but not a huge population of people who are repeat offenders with multiple dockets in our system. If we could do something about those repeat offenders, yes, we would decrease the number of dockets in the judiciary caseload. But to the extent that they continue to offend or violate their conditions of release, they simply have more charges, which gets added to the caseload. I would agree, yes, that if we could do something about those severe, the repeat offenders who are, I think it's something like a third or 20% or 30% of our caseload, if we could do something about that, that would go a long way.
I mean, we've already, the governor, the administration approved last year 4 additional judges, correct? 3?
Yeah, at least 3 last year, but also in the last 5 years, definitely 4.
So we're a small state, a very small state population wise. And it seems like we're not going ahead with falling further behind. And that's my personal opinion of what we're dealing with. Certainly, myself in Washington County, in Berlin, Barry area, we see a massive amount of stuff going on. Washington, the small town of Washington. I just have that in my mind. The other thing, going back to raising the age, what'd you say? We're already above any other state already?
I wouldn't say, so we went up to 19. I think there's a handful of states that maybe have gone up to 19. If we went up to 20, we would be the only state up to 20. There are not many states that have gone up to 19 with Vermont. Most states, and I think the excitement about raise the age is states moving up to the age of majority being 18. But I would have to get you the states that have gone up to 19, like Vermont. But Vermont is
Michigan, New
talking
York.
about going up to 20, and we would be the only state up to 20.
Okay, understand that. Okay, the beds and the treatment and the beds and the treatment, haven't we been after that and trying to work with the other committees about trying to get a facility working together to deal with that, so we have a place to safely put somebody and also get them the treatment that is needed?
On the last few years, we've really tried to work on finding and I guess formulating how to best approach a forensic facility where you would put people who are not competent to stand trial, who are adjudicated not guilty by reason of insanity, but who have committed horrendous crimes. That has not been a tremendously successful effort. That's not what we're talking about here. Here, what we're really talking about is, and this may even be repeated disorder, offenses that cause disorder and fear in a community. But retail theft is a good example. We went to Rutland County, Rutland City, about I don't know, 2 or 3 years ago now. And one of the data points that they gave us was 75% of retail thefts were estimated to be caused by known drug users. So the theory would be, if you can actually intercept that drug user at a point where they are either pre-charge or pre-trial or even post-adjudication, if you can actually successfully treat that person for their drug use, you can, that's a relief to both, as Representative Rachelson pointed out, to the justice system, and to the community. So that's the goal, I think, that we're going after. We always say, if you only had treatment on demand, you could get some of these people treatment when they walk in the door. So we've been working with AHS to come up with a system of delivery where people are more hopefully likely or able to get treatment on demand when they're at that point.
So
That's the goal.
when we went up to the $900 for the retail theft, like the people that are doing that are committing those crimes, there's got to be a black market, for lack of better words, that material is going somewhere. They're not just throwing that out on the streets. There's got to be some organization. There's got to be some organized crime thing that is spearheading that, so they can.
Oh, is that a question? No, I'm just waiting if that's a question.
Yeah,
Okay, yeah.
I was getting there.
Okay, thank you.
So he just screwed me up with my question. My question was,
You're going. I think that maybe organized crime is part of it, but this initiative is focused, I think, more on individuals who are perhaps committing retail theft either to sell things to support their drug habit or because of their drug habit, they just don't have the necessities that they need. I think that's the person that we're after here.
So I agree with that, and hopefully we can help help them get what they need and maybe get off the drugs and all that stuff. But a lot of these people are the same ones that are doing this over and over and over again. And that's really what we're trying to get treatment for. And also I would say, send a statement out there that enough is enough.
Well, I mean, if you have the option for treatment and you choose the option for treatment and you're successful, the theory would be they're not stealing over and over and over again. They're getting the resources they need. And none of this is going to happen overnight, but we need to start somewhere. We need to start now. And I think that, we are going to have, and again, it's going to cost some money. I don't want to get out ahead of the governor on his proposals, but these are the kinds of things that we're talking about starting up. They require some rule changes with Medicaid. A lot of this is driven by Medicaid reimbursement. We're looking at how do we retool our current operations to do more. That's really what we're looking at.
And then the last thing is we've been trying to place a facility to get help to people. And I forget there was some a smaller town, if I'm not mistaken, and they were dead set against it. And now I think I heard a rumor, maybe Essex is in favor of it. Is that true?
I don't know. I'm not privy to all those conversations. Of course, we have been looking to place a secure youth facility somewhere in the state for probably about the last 5 years or more. So that is very difficult because no town is stepping up to offer a location for that. If there is a town stepping up to offer a location, that's terrific. But we have had a tremendous amount of trouble locating a facility in a local community.
Okay, thank you.
Tom.
Hi, Jerry.
Hi, Representative.
I'm trying to make sure I have an understanding of your public inebriation beds and / mental health facility beds and who goes where, when, or whatever. Past experience was we had mental health, AKA Act 1. We could bring somebody that was inebriated. There was no criminal charges, but was definitely somebody you couldn't leave alone. They would screen them, hold them if they were compliant. If not, they would go to a correctional facility. If they were injured or otherwise, other than inebriation, having issues, you can sometimes go to an ER. And we've lost the most of those services. So it became, you had to go to the hospital, let them see a doctor, get them medically evaluated, then bring them to a correctional center. Is that what this is allowing law enforcement to do, or is it sending it somewhere else?
Hopefully this would be providing two things. One would be, it would not be prohibiting the current practice, right? We need those beds for people, particularly for people who are violent or excessively disorderly. And it would be reinvigorating the system where people would be provided a bed in a community facility. So I think that's the goal is, first of all, we just can't let the ability to place someone in a DOC facility just sunset, because that leaves us with very few resources for any placements.
So you're looking at creating a facility or utilizing something pre-existing, such as a hospital?
Pre-existing, I think the care providers who have previously done public inebriation beds and no longer do, or providers who have gotten or theoretically going to do public inebriation beds and they couldn't get started up for whatever reason. Like, I think there has been a public inebriation program in place for some time. I don't know how effective that has been. I think ineffective. So I think that what we're trying to do is create both an effective program for the community and not rule out the option of a placement in a DOC facility when necessary.
Okay, thank you. I got it.
And like I
So-
said, AHS would be the best, the providers or AHS leadership themselves would be the best people to talk about how exactly they'd be providing a community resource.
So, before I lose that, I'm gonna put in a bill request, so Eric is right here on that one component of it, because it sounds like there's a lot of interest certainly in us looking at that, and we can look at that. So,
And
before
the
we have
language is
Tucker,
in our bill.
yes, yeah. So, pretty straightforward, just get this cross out what's gonna happen on July 1st.
Yes, yes.
So just one last comment, and then we'll go to Tucker, is that, all this morning, we talked about, our focus was on, court processing, time that takes for cases to go through, for consequences to be close to the offenses, which I keep on hearing, including from the commissioner of DPS, is probably the critical thing that we need to do, is to have the consequences and accountability kind of near. The hot stove issue, as somebody, I think Commissioner Morrison said, and just emphasizing, I'm hoping that we see on the governor's budget proposal the resources needed to continue our efforts, which we did great last year, with being 3 judges, but I know there continues to be needs in the criminal justice system to process cases more effectively. Just had to put that plug out there. You'll be hearing that plug more once we see the budget as well, but just figured out since I had you here, I would put in that plug.
No, I appreciate that, Mr. Chair. I really do. I mean, and the response, as you will also probably hear in the budget, is that very often the solution is not just to fund, but to fix. And that's the kind of thing that we are working on. Throwing
Working on
more
both.
dollars at the problem may or may not be the answer. It may be talking about other options available to the judiciary for managing these cases and diminishing the backlog.
So agree, it's both. It certainly is both. And I think the bills we passed last year, including what we put in the budget, goes towards that, and we'll continue to work towards that. So I really appreciate your time.
Terrific. Thank you, Mr. Chair. It's
Yep,
very nice
yep.
to see you again.
Yep, thank you.
Thank you. Thank you.
Tucker, if you can join us.
We'll roll right into it, or do you want to take a break?
Well, we have to be on the floor at 3 anyway, so
Okay.
we probably should just keep rolling.
Yeah. It's good to know.
No, me neither.
Thank you for being here, and introduce yourself for the record and proceed.
Good afternoon, everyone. Tucker Jones with the Department of Public Safety. Thanks for having me back again today. Today, well, I'll be a little more direct today and get to the point on some of these things. In terms of housekeeping, I have a note in my email from this morning on domestic violence fatalities. And I'm not sure if it was from this committee or maybe it was from the Senate, asking for some follow-up, perhaps on the portion of homicides that were domestic violence related. But in any event, if that was,
It did.
It came out.
yeah, it was and so what I have here is the Domestic Violence Fatality Review Commission 2024 report, which gets into
I don't think you have to go over that right now.
Yeah,
In fact, it
but that's
was,
where-
Senator Vahusky asked that question, and
Oh, okay.
and I actually pointed her to those reports.
Okay.
So
Great. Yeah, sorry, I wasn't there to kind of pick up on that. I have a few handouts that I'll kind of get to, and I've also posted them all, but I printed them off as well. The first is the weather reports that I was talking about from last time from DCF and the Department of State's attorneys regarding those the quotes that I was giving regarding the conditions on the ground that they saw and the basis for the concern that we're really not ready to go forward with the 19-year-olds kind of from those. So I have that. I'll hand that out kind of to start. And I posted these as well. I just wanted you to have hard copies of them. So I really just want to touch on two topics today. One was the rest of juvenile jurisdiction, the other pieces of it. We already touched on the raise the age, but a few other pieces to it. And then if we have time to also talk about bail revocation, and just to kind of get a little bit of the framework out there, some of the thinking on bail revocation and accountability. Now, this is all within this broader context of what we're seeing in the community today, local communities hosting special meetings on the topic of public safety over the past year up through 2024 and into 2025. You know, we're the Department of Public Safety. So when these special meetings on the topic of public safety come up, we follow along throughout the year to see what the topics are that they're covering, to see the news coverage of certain cases that come up, and to make sure we're following the themes and that those themes are being brought to your attention, and where there is a perception of a gap in the state level response to some of the issues that we're seeing, to propose and suggest that there's some legislation to fix some of those. So the next hand I'll give you is my framing of the landscape as I see it today in 2025, from the past basically 6 months of what the kind of media landscape has been, of the coverage of these local communities that have been having these special meetings, the frustrations that have been expressed, the themes that have been expressed in these meetings. And then this is all in the broader context of really two things. One is the big picture statistics, which I kind of alluded to last time with some of the shoplifting, thefts from motor vehicles, thefts of motor vehicles, identity theft, those as being the kind of focal point of the increases that we saw from 2018 to 2023. But in addition to that, the specific case examples, specifically in the repeat offender context, with the ongoing violations of conditions of release and the ongoing criminal activity. Often the cases are criminal activity that doesn't necessarily rise to a felony act of violence, but it's nonetheless persistent in such a way that there is a real palpable sense of ongoing community harm caused by a relatively small group of defendants who are essentially not desisted by being arraigned and released on conditions, despite that happening over and over again. So the handout that I have here for you is basically a summary of some of those considerations, big picture. You don't have to look at it now, but I wanted you to be aware of it. It's general framing remarks followed by some of those numbers that I mentioned, just the ones where we have the most concerning increase. That's really the highlight, where things are going well. And there are aspects out there in the community where we're seeing some positive trends coming out of the pandemic era, but there are some that are persisting, some that remain a concern and affect the broader community. There is a reference there to the homicide victims, and then there's a list of the news coverage there. Now, this is posted so you can actually, have it in a digital form too, but it's the list of the news coverage that is precipitating some of these broader conversations for what's in the legislative proposals that are kind of being considered and out there today. So that's that. Shifting gears to the rest of juvenile jurisdiction. We talked about the 19-year-olds, that decision point, that go, no-go decision on the 19-year-olds. There are outstanding questions on the remaining structure of the juvenile justice system. And there are really just a few. One is what offenses should be starting as delinquencies, and the other is the structure of the youthful offender system. So I'll just hand this out. I gave a copy of this to Eric to look at as well, because this is the list of the current Big 14 offenses in the left column, some of the other listed offenses that aren't part of the Big 14 now, and some additional offenses that just aren't included in the Big 14 as well. I want to go just run through, and I know Kim probably addressed some of these yesterday as well, but I just want to run through some of these. These are offenses that aren't currently part of the Big 14 offenses. So as you already know, you probably got the briefings. These are offenses that must begin as delinquencies in the family division for the applicable age group. So that includes 18-year-olds currently. That includes 18-year-olds currently, and on April 1st, it would include 19-year-olds as well. So some of these offenses are stalking, domestic assault, first-degree aggravated domestic assault, second-degree aggravated domestic assault, lewd and lascivious conduct with a child, recklessly endangering another person, violations of abuse prevention orders, operating a vehicle under the influence of alcohol or other substances with either death or serious bodily injury resulting. Other motor vehicle offenses with serious bodily injury or death resulting. Burglary into an occupied dwelling, because it's part of the Big 12 and then got taken out. Abuse by restraint, neglect, sexual abuse, financial exploitation, exploitation of services, human trafficking, aggravated human trafficking. And then those are in the listed category, but there are other offenses out there in Title 13. They're not necessarily listed, and they're also not part of the Big 12. Now, I want to just touch on domestic terrorism for a minute. If I recall correctly, the domestic terrorism offense was created in response to a gap in current criminal law to intervene when someone has taken a substantial step towards a mass casualty event like a school shooting. And in fact, it was a specific case where an individual, I believe, was charged with attempted murder because they were planning a school shooting. But the court recognized that it didn't really rise to the level of an attempt because they hadn't really gotten close enough to the execution of the offense. So domestic terrorism, if I'm recalling correctly, was created to fill that gap and to recognize that when a law enforcement intervenes before someone actually reaches the level of an attempt, but they've actually taken a substantial step towards a mass casualty event like a school shooting, that is the offense, domestic terrorism, or subsection within it, that it was created for that scenario. The fact that that currently must begin as a delinquency for an 18-year-old in the juvenile justice system with DCF's oversight, DCF resources, and on April 1st, for 19-year-olds as well, is concerning because we don't have a secure facility in place that can necessarily take that individual, and I'm not confident that DCF has the ability or resources to handle that type of situation. The reason this is just one offense, it's a small one, but the reason I point it out is because there are a lot of gaps in the existing juvenile justice system that haven't been fully thought through. And this is just this one of them that we haven't really planned for. And it's important for this committee this session to really understand that the juvenile justice system statutory scheme as we currently have it isn't fully ironed out currently, and it needs a lot of work.
So just a couple quick points or questions or for additional information. Just on the domestic terrorism and some of the other ones, if I'm concerned if the main reason is because we don't have some place to put somebody who's 18 or 19. In part because we've been facing years of delays in getting that facility up. So that becomes the excuse that we're all of a sudden going to send somebody directly to criminal court for any number of these is perhaps problematic, which I would have you address. But a couple things real quick is that, I keep on wanting to make sure everybody understands that these can be moved to criminal court. They're not stuck. The ones that you've talked about can be moved to criminal court. And the idea, the concept, this is going to get to my question. The concept of getting to juvenile court is that it's going to be more rehabilitative. That person who did, that issue, I think went to juvenile court. I can't remember if he did, but I mean, often we may want the individual to get the services in juvenile court. That's the whole concept behind it. But here, my question is, for these various listed offenses, these various offenses that are not in the Big 14, to really, in my view, to change those to be part of the Big 14 is not just to look at it and say, that sounds really bad. I want to understand how we are doing currently in the juvenile justice system with individuals who may have been charged with those crimes. Is the juvenile system working for those individuals who have been charged with those crimes? That seems to be the most important fact. And I ask you if that's something you have, or if that's something you can track down, or how do we get that?
Yeah. So this is one aspect of it, is these offenses and the interventions there. Now, a few points to get to your last question. The delays, the reasons that we don't have the facility, et cetera, obviously within the scope of your interests, and you want to sort that out, make sure the money's there to build it, et cetera. But there is this reality on the ground where we need to have the interventions available to intervene on the day of, to make sure that these situations are handled right away in an appropriate manner. There is all these provisions to transfer these cases, go from family to criminal, other way as well. But when you make these decisions of where they start, you're making a policy decision of really where they should remain in your judgment as a matter of policy, that you're saying it's starting there for a reason, and you believe it should be there. So
I don't think it means that we are saying it should remain there. I think there's maybe a presumption, but there's a path with the criteria for it to move in the appropriate circumstances to the criminal court. My biggest issue is that it takes over a year to do that. That's a problem.
And that is a problem. And the real problem is what happens during that intervening period of time. What does a juvenile condition of release look like when it's violated? What occurs when there is an ongoing violation or a new crime? How do we address that in a way that actually results in some desistance, that actually results in intervening and stopping it? The concern with some of these more serious offenses is that the juvenile conditions of release and the process within the juvenile system doesn't really have the teeth to actually result in desistance during that time period when we're considering a transfer up. And that's kind of an ongoing concern. It's been articulated through some of the feedback from the Department of State's attorneys.
So can I ask a question on that, just because I want to make sure I understood the testimony that we've got the last couple of days on that the concern there is certainly for 18 and 19-year-olds, well, we'll just talk 18-year-olds because they're in the system now, that we don't have really a place to put them. They would be, so they can't be in Red Clover, for instance. So that's kind of one part of the concern. The other is that they age out. And so are those the two main kind of the accountability for that you're talking about, or is there more to it?
Yeah, those are the main pieces in delinquency. So the mechanism to kick out in some quick manner when it's clear that voluntary compliance with the juvenile conditions of release is not forthcoming. That mechanism, over time, you've added some language of the past few years of saying, well, this hearing should happen quickly. There's some question over whether that's sufficient to actually result in the kick out. So that's one aspect of it. The age out question is real too. Some of these very serious offenses involve, for example, death, serious bodily injury of another person. And we are relying on a period of supervision. Once you get to adjudication, if you get to adjudication in the family division, that can be very, very short. And we don't really necessarily have a period of supervision that accounts for the severity of the conduct. So that's another piece there of the age out where you essentially run the clock. And that's, it's a missed opportunity when these things happen because really the lesson that we're giving young people is that there isn't going to be much of a consequence for some of this behavior. And it can, that can, in certain circumstances, really have a bad effect on them down the road. And it's not even about punishment per se, but that actually serious adults in the room are actually going to do something about this, that when you don't have that, it can result in those effects.
Great. Ian and then Angela.
So yeah, we've heard about the age out. We've heard about, I think a lot of the testimony we've heard on juvenile cases, I feel like I've got info on. But one thing that you mentioned in your testimony today that I haven't heard is issues with juvenile conditions of release. Not the consequences. I think that I understand. But is your testimony that you have issues with actually what prosecutors are able to ask for within the constrictions of juvenile conditions of release that they can't ask, that they could ask for in criminal conditions of release?
Yes.
Okay, what is it?
Well, in the criminal court, there's a host of options available. And we're talking all the way through the bail presentation today of actually seeking bail, actually seeking detention in DOC facility if necessary for ongoing criminal behavior during that period. One of the concerns that was expressed to me by Deputy State's Attorney handling these cases is that they can seek a bench warrant to have a youth appear in court to hear when there's a non-compliance issue with juvenile probation or juvenile conditions of release. That can happen. They can arrive in court, hear that they really should be listening to their DCF probation officer, but then the hearing's over and there's not another mechanism to ensure compliance after they walk out of the room from that hearing. And so what do you do there? And that's when you have this age out phenomenon where essentially at a certain point, the probation officer throws up their hands, and these cases, you can ask for another hearing, come back later on, and then you're in that cycle. You're in that cycle. And I think there's some level of frustration in that scenario.
That still sounds like compliance though. And I'm more wondering, are there things that you can't ask for in juvenile conditions of release that you can ask for in criminal conditions of release that you want them to be able to ask for in juvenile?
Well, what we're saying here is with some of these offenses, by starting with criminal conditions of release, you'd have those mechanisms from the get-go.
For compliance, but okay.
But yes, I mean, there's basically the enforcement capacity is just greater there.
Okay.
These offenses, though, the offenses are just one aspect of it. The other is the overall structure of the youthful offender status. And in any event, this topic is not new. 3 years ago, DCF submitted a memo to the legislature asking for structural revisions to the delinquency proceedings and youthful offender proceedings. That memo is essentially the blueprint of what is being proposed to this committee today. And then I have a copy of that for you all as well. It's from 2021, and it lays out these issues from DCF's perspective and their proposed structural revisions of that system. I'm not going to go through all of it now, but you'll see that it tracks a lot of what's being kind of considered in some draft bill language. And one aspect of it, which I can touch on, is the other aspect. One is the offensive categories, and the other is the structural youthful offender status. Right now, someone can apply for youthful offender status, you get a consideration hearing, a determination is made of whether to transfer the case to the family division on this youthful offender status, and then they can contest the merits of the underlying allegations. As you've probably heard, the prior structure of youthful offender status required a young person under age 22, right? It's YO, it's this older age category, under age 22, to enter a conditional plea in the criminal division to get the benefits of youthful offender status. That is one of the proposals here, is to revert to that prior structure. The logic being that the acceptance of responsibility for the underlying behavior is good for the youth from the beginning, because they're getting conferred this benefit to be having their case treated in the family division after that. It was one of the recommendations to revert to this structure at that time, and it's still out there as a consideration. So those are some of the considerations for juvenile jurisdiction beyond just the age 19 thing. I just add that I think some of the negative feedback that we've gotten on the current state of the juvenile justice system is in part due to the fact that these concerns were adopted several years ago. And there are other factors, of course, at play as well with a secure facility in the pandemic era issues, but it's something to consider that these were raised several years ago, not ultimately adopted by the legislature. I know you had some of those. Anyway,
Well, I think Angela has a question. So you do as well.
Sure, thanks. So my question goes back to just maybe like a half step to before we were talking about the 2021 memo. And when you're talking about the crimes that cannot that are not on the big 14 list, and this issue of what happens when while the transfer is pending. And I hear that as a concern, as something that needs to be addressed. But my question, I guess, is it seems to me that simply, adding to the list of offenses that can start in criminal court is really the bluntest of instruments, and that it's a way you're going to catch up in this, like, so many potentially youth who are not in the small group. It's been said to us over and over again that it's a relatively small group of youth who are not completing their juvenile probation. They're violating their probation. So for that, because of that small group and our inability, the state's inability to effectively care for and rehabilitate them or process in a criminal proceeding when appropriate, we're going to take this huge step that will encompass all youth who would have otherwise potentially gone through a juvenile proceeding and followed their probation and gone on their way and not committed other crimes, and just they're going to potentially get wrapped up in the criminal process, which we know has poor outcomes. And so I'm just wondering how we can really responsibly justify that approach when it's not, we're putting a lot on the youth. We're saying it's their fault and they have culpability, but so does the state. And I haven't seen anything that shows me that the state is necessarily, these 18 and 19-year-olds are not responsible for the court backlog. That's on us.
Yeah, to be clear, it's not, of course, they're not responsible for the delays. It's the non-compliant behavior and the pre-adjudication and then supervision context that's where we have the issues. If everyone was compliant, then we wouldn't be necessarily having the negative feedback that we're having in the current state of the system. And I think it's our inability to respond effectively to that non-compliance that's creating some of the consternation about the current state.
Right.
Obviously, we're not blaming these young delinquents for the fact that we don't have a secure facility. That's not the issue. It's just really our inability to respond to the non-compliant behavior that does lie with them.
Right. So I would like to see more of a focus on the response.
And so I said this is blueprint with one caveat, one addition. What this doesn't include is the kick out provision for delinquency adjudication, delinquencies.
Useful offender.
No, the kick out provision for actually does address youthful offender status, but for a delinquency, the mechanism to return a court to criminal division when you have some non-compliance, either in the pre-adjudication or in the supervision space.
It's not there.
It's not in that memo.
It's not in 2021.
So that's
Oh,
added.
that's a needed, that's.
It's an add in top to it.
Okay.
Otherwise, though, that memo includes a lot of very good stuff. So I do recommend reading through it and understanding it. You know, part of this too is this came homegrown from DCF 3 years ago. One of my points I was trying to get across earlier in the week was the importance of relying on these weather reports from the individuals that you've tasked with implementing juvenile jurisdiction in the state. They at DCF are the subject matter experts on the operational implementation of juvenile justice in the state of Vermont. So when 3 years ago, they came forward with their concerns about certain, the legislative structure of how it's done, they weren't doing it for fun or in jest. They meant that seriously. So, it's another weather report. And when we don't, listen to the weather reports, then it can add to the problems at the end of the day. But that's the framework, 2021 plus.
So I'm gonna give Tom the last question because we do have to end for the. Yeah, Barbara's conceded to you.
It won't be good for you, Barbara. With some of these, I wouldn't have an issue putting them over with the Big 14. And the reason being is, I think the reason that we do this is to protect underdeveloped brains from their bad decisions is a big part of it. And you could have had the floor.
I know, I'm sorry,
Okay,
I'm
just
sorry.
saying. I mean, to me, lewd and lascivious with a child isn't a bad decision. That's goes beyond a bad decision. Could operating a vehicle with death, injury, negligent operation, leaving the scene, I could see putting those into a bad decision area. Human trafficking, that's not a bad decision. That is something that's planned out over a long period of time. Aggravated human trafficking, I would have no problem putting over in the other column. I mean, possession and use of weapons of mass destruction, that's not the bad decision of a child. Especially when it gets into the use, maybe the possession, but not the use, certainly. And the same with explosives. I guess I could go either way with that. But when it gets into violating children sexually, I have no tolerance for that on any level. I mean, use of a child in a sexual performance, there's a lot of planning that goes into that and not just a bad decision. And possession of child sexual abuse material. I mean, luring child, it doesn't give a real explanation. Anyway, that's just my 2 cents. Probably not gonna change. That's my 2 cents.
All right, so you didn't have the last question, but you had the last statement. Yeah. So
Yeah.
question. So I assume you have more that you want to, because we can reschedule you for some other time the next couple of weeks. I definitely want to understand a little bit more about the youthful offender changes.
Yes.
That may be part of what I'm actually frankly working with Eric, given all the testimony we've had the last 2 days, to have a proposal. It may not look like the youthful offender proposal here, but I will throw it to you just in the interim. If you could let me and/or Eric know how your youthful offender proposal or the administration's gets around the case of Hartford Current Company versus Carroll 986 F 3rd through 11th, Second Circuit.
Yeah.
And you don't have to tell me now if
Yeah.
you're already familiar with that. I just want to understand how you get around that particular case.
Yeah, there's a lot to, a lot to unpack on both of these still, delinquency and YO. The framework there is out there though, so you kind of have that. And there's more to be, discussed as to the ceiling of criminal proceedings.
Not a lot of sense.
And but there's a little bit more that's probably worth discussing in the juvenile justice sphere. And then there's a very interesting conversation to be had, I think, about the repeat offender violation and conditions release and ongoing criminal activity in the pretrial space.
Is that in the bail revocation?
And the idea of bail revocation and some of the other legal mechanisms out there. That's the other area of some focus, and I think it might be worth discussing that at some point.
Yeah. So I did mention earlier that I have a bail revocation bill drafting request, but I think probably the Senate is going to be taking up the bail issues first, as well as the ceiling issues. We're doing the juvenile justice, youthful offender issues first. So
We'll
we
save
may
it.
not see you before crossover, at least on the bail ceiling issue. So
No problem. So deal with that. No.
traffic control that we're having.
Yeah, and thank you all. You got a lot on your plate with the juvenile stuff. So best of luck ironing all that out in the coming
you.
weeks. Thank you, Tucker. Thanks, guys.
You.
Great to get CSG in here.
Yeah.
The partner of
Good evening.
Utah, the states that are doing this.
Good to see you, Don.
So the stuff started. There are millions, there are thousands of studies over.
I should. Not quite yet.